Assalamu alaikum wa rahmatullahi wa barakatuh. Today's class session will look at the trade-based financing product. In our previous classes, if you may recall, we discussed about a participatory contract. What does that mean by participatory contract? It's the kind of contract that two groups of people are involved, which both contributed their capitals, or one contribute his capital while the other person give his expertise. But today's class will solely look at the non-participatory contract. When we said non-participatory contract, we are referring to a contract that based on financing an asset or financing a business in order to have a profit at the end of the day, or cost plus. Okay, the non-participatory contract, there are many, but the mainly one, the one that was well known, there are three while the others are moving under them. We have Murabaha financing and Salam financing and Istisna. But today we are going to look at the Murabaha and Salam and what are they related to them. Okay, Murabaha financing. Murabaha financing is a kind of buy. When we say buy, we are referring to a sell. It's a kind of buy that is based on trust, which is amana. When we say trust in Arabic, we are referring to amana, where sellers names, or the seller name the profit makeup that is applying on the cost price of that goods. So the person, that is the seller, has assets and name the price, that is the cost plus on that particular asset, additional to the real price of the assets. So we know that, or we already understand that as what? As Bay al-Amana, Murabaha. So where did this Bay al-Amana comes for? When we look at it, Bay al-Amana, it means the Murabaha is based on trust. It's based on trust because you can buy a product, name the cost of the product and also the profit plus or the makeup in order to sell it to a customer. We have another way or method of doing that, but when you do not name the profit, you do not name the makeup on that particular asset, we refer that one as not a murabaha, rather than we call it al-musawama, as we are going to discuss it later on. Okay, it is a term of Islamic Islamic fiqh, that is Islamic jurisprudence. It refers to a particular kind of sales having nothing to do with the finance in its original sense. But when you look at the Murabaha originally, it has nothing to do with financing anything. It will just for you to go straight to somebody, request that particular item from the person. If the person is selling it, the person will give it to you and also add makeup on it to pay him with the makeup. So that one can be installment basis or can be at once. But a lot of scholars has discussed the issue of Murabaha by saying Murabaha mostly should be done through installment. But that one is not an acceptable view 100%, because there are some scholars that says no, you can pay your money and take the item. Okay, the word Murabaha is derived from ribha. Ribha, it means a profit, which means gain, profit, or addition. A cost plus sell contract in which parties bargain on the margin of profit over the non-cost price. So after knowing exactly how much that asset is cost, you have nothing to do with the cost of the price. Only what you are to start bargaining in order to have a solid business is the markup. Markup, that is where you can bargain, you can ask for a reduction, or the seller can resist on the amount said without reduction. That one is the way the bargaining is. But the cost of the price, the cost of the product has nothing to do with reduction or addition. Okay, the seller has to honestly reveal the original cost of the underlying and provide all cost-related information to the buyer. That is how Murabaha is transparent. It's transparently related, that you are to honestly reveal the original cost of the underlying assets and provide all information related in order for the buyer to look at it and pay his money. It can take a form of spot sale or credit sale by mu'ajjal. So that's exactly what we are saying. That can be on spot. You can pay the money and take your asset, or can be based on bay al mu'ajjal, that is credit sale. Maybe credit sale in the sense that you trust the person and you give him credit. He will be paying you in installment basis up to the end of the payment. It can be differentiated from musawama, whereby the parties bargain on price without any reference to original cost. So in musawama case, you have nothing to do with the cost price. Of course, he will not reveal the cost price on that particular product, but that is the markup has to be discussed on, and also how much will be the distance. So musawama, you are not to even mention the name or mention the price of the product. That one is also allowed. Okay, musawama is a general kind of sale in which the price of commodity to be traded is stipulated between the seller and the buyer without any reference to the price paid or cost incurred by the former. It is a different from murabaha in respect of the price formula. So musawama, no need of you mentioning the name of price or anything. You add them together and send it to the buyer, and from there the buyer will understand that you have the cost price in it and plus makeup. So now you're going to ask for bargain, but it's not necessary for you to reveal the cost price as murabaha finance or murabaha contract. Murabaha is simply a sale. It is originally sale connotation. The only feature distinguishes it from other kind of sale is that the seller in the contract expressly tell the buyer how much cost has incurred and how much profit he is going to charge in addition to the cost. But in musawama, the cost price and profit are merged together without dignify it, the original source to the owner. In that scenario, you have no right on asking how much. That one does not necessarily important to you. What is important, if you want to bargain or ask for reduction, that will be between you and the seller. Murabaha gives both professional and non-professional participants in the market an opportunity to identify and compare value of money and provide a means of ensuring the profit seller without displaying or keeping a record of retail prices. So Murabaha also is significant by understanding such. Okay, let us look at the Murabaha Mu'ajjal. Murabaha Mu'ajjal al-Bay bi-Thaman al-Ajil. So they are all the same thing. You can use BBA, that is al-Bay bi-Thaman al-Ajal. Bay bi-Thaman al-Ajal, or Murabaha Mu'ajjal. So it's an Arabic Marxist, but they are referring to Murabaha, which is Murabaha based on credit. This refers to an arrangement whereby an Islamic bank often requests by a client purchases an underlying from a third party, sells the underlying to a client on a deferred payment basis. So how that works is when the agreement takes place between the bank and the client, so the bank will invite the third party in order to request that purchase thing from the third party, which we call that third party as the agent. And the agent will buy the will buy the underlying asset to the client. but the agent has to deliver first to the client, to the bank, before the bank issued to the client, and that the payment will be in a defer payment basis, as we are going to see it in the future instances. For Murabaha Mu'ajjal to be legal, the bank must purchase a commodity through a contract and sell it to the client under a separate contract. So you can see, first of all, when the client comes to the bank, asks the bank for that particular item, the bank will look at it, because the bank cannot buy all the items and keep it under its control because the risks related to it or associated to. So what will happen is they have an agent. When you bring your own needs, they will instruct the agent to go and buy such needs and bring it to the Islamic bank. In that scenario, Islamic bank take the possession of that particular commodity and later deliver it to client under a separate contract, as we mentioned. A deferred murabaha price, which is the set higher than the spot cash and carry price, is objected by the sum of the Islamic bank and finance scholars. But when we look at it, as Ayuba mentioned in 239, if you look at it, some of the scholars has a disagreement on cash and carry. When we say cash and carry, that is payment on spot. You pay them money and you take the property. So if that, why are you instructing a bank to go and look for it? If you have a cash in your domain, why can't you take the cash to the shop and buy the item by yourself? So from there, they are saying, scholars are saying, they objected by some of the Islamic banking and Islamic finance scholars, as murabaha has to be deferred price payment. But according to the contemporary Sharia scholars, murabaha mu'ajjal is legitimate, provided that the risk of transaction is borne by the financial Islamic bank until the position of the underlying then passed on the buyer. So some has, like I've said, resisted that yes, it's allowed. Some says it's not, but mainly people are saying bay al-mu'ajjal is allowed, because bay al-mu'ajjal is allowed due to the possession risks. It has the product has to be distinct, has to be through you, and also you take the risks as a financier. The person that is financing or the institution that is financing this product has to have a possession of the product. So risks of possession, risks of transportation, risks of transaction between the buyer, the agents, the buyer agent, and the financial institutions is being taken by what? By Islamic bank. Then pass it to the buyer, and then later on to the client, you deliver the product to the client. Because of that risk position, that this thing become eligible. We further look at this Bay al-Mu'ajjal. This is show BBA, that's Bay al-Mu'ajjal from theoretical perspective. Assume no civil requirement for the bank's client to enter into S&P. When we say S&P, we are referring to sales and purchase contract with the property developer. A financier buy an underlying asset and sell it to a firm at the cost plus markup for a deferred payment. So in this scenario, we already talked about those things. That is the financier, that is the person that is financing or buying this underlying asset, has to take the possession and also has the cost. He's looking for profit. So he need to, under murabaha, state out the cost plus and markup of the deferred payment. So it will be well known to the buyer. Practical murabaha. Let's look at the practical murabaha, how clients approach Islamic bank looking for a financing or looking for a assets. So the client, first of all, come to the Islamic bank. Have you seen it? So client goes to Islamic bank and what? Write a al-wa'd between the client and the Islamic bank need to be signed. A wa'd need to be signed between them, because you can't just, a client cannot just enter the Islamic bank and request for something, and later on when the Islamic bank bought the item, the client may say, no, I don't want it anymore because I have this legal binding. So in this scenario, you are to sign an agreement between Islamic Bank and the client as he will buy the asset when purchased. So the Islamic Bank, after writing that agreement, has to look for his agents. And in that scenario, an Islamic bank engage agents to purchase the product from the vendor. So from there, the agent will go and look for the asset and get the asset. So when the agent get the asset, straightforward, you take the asset to Islamic Bank. The asset to be processed and transferred to the Islamic Bank because he will not hold the asset under his possession. He has to transfer the asset to Islamic Bank as instructed. And from there, Islamic Bank will now deliver the product to client. So deliver the asset to the client at the end of the contract. So you can see how the contract is being carried out. First, it seems to be 2 to 3 contracts. Number one, the first is to sign the agreement between the Islamic Bank and client by giving assurance that you buy the asset after getting it. So the Islamic Bank will go down to look for an agent. That is, the Islamic Bank has agents separately. So from there, the contract also between the agent and Islamic Bank will occur by looking for the asset. After getting the asset, he has to deliver to Islamic Bank first, and the Islamic Bank will assign the contract of selling, taking it back to the client with the cost plus. That's how practical Murabaha is all about. Potential benefit of BBA. When we say BBA, like I've said, that is, what are the potential benefit? The potential benefit is fixed selling price. Yes. And the imputed profit rate must stay fixed even though cost of fund have changed. So in the issue, when you agreed on the price and everything, even in the future instances, cost has changed, it has nothing to do with your own contract because your contract has already signed and bind. So number two, changing the profit rate according to the market rate will increase the contractual selling price, which violate the act principle that requires only one price in the one sale. So here, by changing in the profit rate according to the market rate, it won't touches your own destiny, because if they change, it means has violate the act principles. So when we said act principles, that's the contract principles, and that is another topic which we may consider it under buyback contract, which is not allowed by URDU. So non-penalty on late payments. Initially, you have not to charge any amount on any penalty when the payer or when the buyer defaulted in paying. You are not to charge him any amount in order to maintain your product value. No, but late management fee may be imposed. So you can impose him a penalty management fee, but late management fee may be imposed. Some of the scholars are saying it won't be possible if that has been agreed on, no need of any management fee. Only some are saying you pay penalty, and the penalty, it will not be used by the bank. It has to take to charity organization if you defaulted in pay negligently. Okay, that's Murabaha to the purchase order. MPO, Murabaha to purchase order. That is exactly the way we said about the word. Murabaha, you have to have a purchase order before you go for it. So Murabaha to the purchase order can be defined as an agreement where the two parties negotiated, agree a specific term of a sale contract, and promise each other to consummate it. So MPO exactly is the same as what initially when somebody comes to you asking for the product, asking for a contract, you are to have a common agreement on that specific terms by agreeing, both parties agreeing and promise to commiserate at the end of the day when you guys have the product. Under MPO, when we say MPO, we are referring to Murabaha purchase order. So three separated contracts may be involved: master contract, agency contract, and Murabaha contract. That's what I said. Master contract, the bank client agreed or promised to purchase the underlying when offered by the Islamic bank. So you have to sign this. Yeah, you agree that you are going to, or you promise, you agreed you are going to buy this when Islamic bank buy the product. 2, under master contract. This differ from conventional forward contract because obligation to buy binds only the client, one side promise. So here it's different with the forward contract. As a conventional forward contract, we know how that works. But under Islamic contract, only one side is buying only. That is the client, for him to buy or promise to buy the item. Number 3, the bank has implicitly acquired a right to sell at no cost. So the bank here cannot sell it, the item that has no cost, no right to can sell the item when the item is beyond available under his right, and also acquire the right to sell at the no cost. It means that his right to sell, you have to have the possession of that particular item. Okay, number 2, we have agency contract. We have discussed about the master contract. Now it's agency contract. The agents, that is the bank client, purchase the underlying from the identified supplier and take its position on behalf of the bank. So the agency, the person that will be involved in it, that is the second party, he has to go and possess the underlying asset, identify it based on the stipulated description by the client, and possess on behalf of the bank. So from there, the purchaser by the agent should be made before this contract is signed. So after agreeing on it, the agent will purchase the underlying asset and also take the underlying asset to the bank, will give a raspberry al-ina. But if, for instance, the bank or the client, the bank will buy, the bank appointed the client as an agent and also buy from the agent and sell it back. Now we are referring to this as a bay-ul-ina. That is, you buy two things. You use two prices on a one item. But the client in this scenario has to go and look for a what? Third party to buy it and buy from him, so that it will not be bay-al-ina, that is, buy back the product. I hope you are getting it. So that the bank will have to ensure that the supplier is a third party, and that the client has not already purchased or made a firm commitment to purchase the underlying asset from the supplier in al-bay al-ina, which is non-sharia compliant. And the third part of the contract, which is murabaha contract itself, ownership of the underlying should be evidently belong to the bank. So the bank should not start agreeing on the cost price without underlying asset. It has to possess the underlying assets before they discuss about how much and how to sell it. The client is now obliged to purchase the underlying asset from the bank, whereby the underlying price, cost plus profit schedule of payment and maturity are to be specified. So all those things has to be specified. You have to talk about how many months you have to take before you pay me before you pay back the money, and also you all need to state that duration. Okay, let's look at the condition to murabaha. It is not allowed to conduct murabaha on a deferred payment basis in the case of currency. You can't give a currency, that is the money, just like that, and ask the money the clients pay you back with the money in a different forms with the interest in it, with the cost plus. That one we call interest, because monetary unit is just a medium of exchange, subject to the rules of buy as sarf. So the money, you can't do that with the money. It has to be asset involved. Receivable or debt instrument cannot become underlying or murabaha contract. So a debt instrument cannot also become a murabaha in the contract. It won't be. It has to be asset, physical asset. Buyback arrangement and rollover in murabaha are not allowed. Therefore, the bank must ensure that the goods requested by the client are not already in the client possession. So it has to be under, even the product or item is yours, the bank has to buy the product from you and take the possession. And the bank will have to keep the possession, the product with them. If you want, you can go and apply for it. But the possession is not under the bank, which is most of our Islamic banks today are doing such. Before the possession comes under their they start think of the profit making on it. In the case of property financing, civil law required S&P, that is what sales and sales and profit arrangement or sales and price arrangement to be signed between the bank. Sales and profit, sorry, to be signed between the bank's client and property developer. This requirement has forced Islamic bank to first buy from, then sell back to the property to the client. So you can't just start selling the property without making ownership of it. What makes Murabaha Sharia compliant? Simply, you need to know that the difference between money and commodity in Islam. So Murabaha cannot be conducted based on money. It has to be a commodity, which is the asset involved. The main differences between money and commodity are money has no instinct utility. Commodity can be of different qualities. Two, the transaction of sales and purchase is effected on a particular individual commodity, or at least on the commodity having a particular specification. But money, no, on the contrary, cannot pinpoint it in an exchange transaction. That is the money. However, evidence from the Quran and the Hadith is usually used to justify the application of Murabaha. For example, it is not crime in you if you seek of boundary of your Lord. That is, it's not a crime. It's not an offense to you to look for Allah's bounty upon you. So, Baqarah chapter 2, verse 198. Sharia rules concerning Murabaha. There are many rules regarding contract of sale. However, the main three rules are as follows. The subject of the sale must exist at the time of selling. Definitely, you have to have the subject matter of the sale. You can't just do something without having the subject matter of it. The subject matter of the sale must be owned by the seller at the time of sale. So when you are selling it to that person, the person has to have that item and also owned by him under his possession. Number three, the subject of the sale must be in a physical or constructive possession of the seller when he or she sell it to another person. For example, A has purchased a car from B. B has not yet delivered it to A or to his agent. A cannot sell the car to C. So even you purchase a car, but before delivering to you, you cannot sell it to someone unless the car is there under your possession. If he sells it before taking a delivery from B, the sale is void. So if that happens before, it means the contract is invalid. So that's how Murabaha works and how the example of Murabaha is being carried out. Let's look at the Salam. Salam financing. Salam, what does that mean by Salam? Salam is a kind of contract, is a kind of forward contract. Is an alternative to conventional forward contract. A Salam in normal sense, you cannot do the Salam in a normal instances, but you do the Salam in a kind of specific product or contract as specified. Salam is a sale whereby the seller undertakes to supply some specific good to the buyer at a future date in exchange for an advance price fully paid at spot. The buyer pays the seller the agreed price of an underlying which the seller promised to deliver at a specified future date. So in this scenario, the Salam is for you to pay money from the product you do not possess it, you don't have it on your, that is to pay this, the product that you have no knowledge on it, but has a specific feature and attributes, and at the end of the day, maybe after some time, you can have the possession of it. The seller get cash now. You pay the seller now to invest in the sourcing production of the underlying. So from here, you pay him in order to invest. So at the end of the day, he'll bring the investment to your ends door. It means we are referring that to agricultural product. The buyer eliminates the uncertainty in the future price. So they have both benefit because the buyer here, he eliminates maybe he may think that in the future date, the price of this product will go higher. So now they agreed on a certain price and allowed them to go and pay the money in order for both of the parties to invest in agriculture and have it in the future date. Salam was allowed by the Prophet ﷺ subject to a certain condition. Not all commodities are suitable for Salam contract. It is usually applied only on fungible commodity. As I said, it's not all the contract is being allowed to apply Salam in it. The Salam is only on agriculture. How Salam works? Let's see how the Salam works. First of all, under the Islamic Bank, let's look at how the Salam works. Client approach Islamic Bank for funding agri farm for a period of 7 months, for instance, from January to July. So, and Islamic Bank agrees to look for another party to accept to find a buyer to accept the product on that due date. So on July, maybe next July, from January to July, the product will be delivered to the person. The buyer accepts it. And now the Islamic Bank comes to the client and cash the money, cash the required amount to the client and asked for the specific product and specific number of product and also agree to open by the buyer. So in this place, in this time, the client go and invest in agriculture and at the end of the day, he got his product intact. So after farming and harvest what is expected, the client take the delivery to Islamic Bank. So the product will be delivered to Islamic Bank and the Islamic Bank will deliver it to buyer. That's how IB delivered to buyer on the same date, July, as pre-agreed. So that is how the contract, Salam contract works. So Sharia ruling concerning Salam. The commodity under a sale contract must be in the physical or constructive possession of the seller. And this case has 3 elements as follows. The commodity must exist. The seller should have acquired ownership of the commodity. Mere ownership is not enough. There are only 2 exceptions to these general principles in the Sharia. Salam and istisna are both sales of a specific nature. Therefore, Salam cannot be tied to the produce of the particular farm field on 3. That's how the Sharia rulings concern Salam, and they are only born on 2 things. Thank you for listening. I hope you find it useful. And inshallah, if there is any questions, expansions, criticisms are all welcome. Today's we focus only on Salam and Murabaha. So the later date, maybe in our final class or next coming class, we are going to discuss more on the rest of the topic. I think you find this useful and thank you for listening. If there are any questions, the door is open and you can go ahead and start asking questions. For those who are in need of those who submitted their application will be reviewed in 2 to 3 days, and also the report will be summarized, and we will discuss that in our next class, inshallah. Thank you. Assalamu alaikum wa rahmatullahi wa barakatuh.